I'm excited to be with you here today. We do have offices in both Fargo and Bismarck, and have great teams there as well. So we're practically in your backyard, even if I'm calling today from St. Paul. So today's presentation, we'll talk a little bit about the immigration team. We have the largest immigration team in the region. We've got a lot of great attorneys and then wonderful paralegals and assistants who make the magic happen back in the office. But this is just kind of a quick synopsis of the team. I'll circulate the PowerPoint slides afterwards to Emily, along with some additional materials if you're interested. And then we'd always be happy to set up a consult if you have specific questions about your work and how immigration could be used for and retention. So today we'll go over kind of basic immigration concepts and terms. We'll talk about the life cycle of an international employee's immigration journey. We'll talk about kind of the various non-immigrant visa options as well as the permanent residence process. And then just some tips for employers as they're thinking about sponsoring employees and kind of moving forward in that sphere. So obviously I'm kind of preaching to the choir here, but why should immigration be considered as a recruitment and retention strategy? Well, you all know it even better than me. But the labor shortage is just at a critical state right now. I think on the next slide, the current unemployment rate in North Dakota is 2.1%. Minnesota here, it's 2.5%. I mean, these are unprecedented numbers. It's always been tough. North Dakota has always had a historically low unemployment rate, so you've been doing it for a long time. But really, the whole country is feeling the squeeze right now. This is a great quote from the Land O'Lakes CEO just a couple weeks ago about the importance of immigration for recruitment and retention for specific companies. Her focus is on the agricultural co-ops that Land O'Lakes supports. But really, this is true across all industries. And this quote kind of highlights the fact that there's this huge labor shortage, and it has kind of ripple effects through the economy and for consumers, everywhere. Everyone's seen their grocery prices skyrocket, and that kind of can get down to supply chain issues and labor shortages. And immigration is a key part of meeting that dire need. Here again, we have significant unemployment rates. There's both need for temporary and seasonal work, as well as long-term need for workers. As we all know, we also have a retiring workforce and an aging workforce, and also kind of a mismatched workforce. The workforce we have isn't necessarily trained, whether that's kind of in professional IT, technology, heavy jobs, or even on other kind of more manual labor jobs or kind of skilled labor jobs. We just have a mismatched workforce. And there are long-term solutions for that, revamping education, making sure we're hitting all of those. But the problem is it's such a long lead time. And so you can kind of, start education now and revamp the education now. But in 20 years, the needs can change, and they often do. So it's tough to really match up our current education system with the jobs that are going to be needed in 20 years. So we're feeling that now. And chances are we'll be feeling it in 20 years as well, because it's so tough to predict. And we also have urbanization, right? So we have a lot of rural areas that are difficult. They're difficult to get physicians. They're difficult to get workers in ag. They're difficult to get skilled professionals at all levels. We have people kind of moving to cities, which makes it really difficult if you're in a smaller town. I hail from a small town in Pennsylvania, a dairy farm town, so I totally understand it. But it's difficult to recruit people, and maybe difficult to recruit people to North Dakota. They haven't, foreign nationals might not have seen it in the movies. Heck, U.S. citizens have hardly heard of it, except for that one movie. So it can be tough just because you're not top of mind. It's a great place to work. It's a great place to live, but it's sometimes tough to recruit and retain individuals. And so immigration can be a really great way to meet your kind of short-term urgent needs, but also kind of a long-term need for you as an employer, but also you as a community. So just some basic terminology that we'll be using today. All of you are familiar with the I-9 process that you need to complete for all hires, whether they be U.S. citizens or lawful permanent residents or immigrants. So individuals need to present adequate documentation of their identity and their employment authorization in order to work for a U.S. employer. And so we'll talk here about various immigration strategies and really focus on the employment authorized categories. There are other categories like a B1, B2 tourist visa, but that wouldn't enable someone to work for you. So we're going to skip over all of that and really focus on the things that would meet the I-9 requirements so that you could actually hire someone and have them work for you. Some questions that you as an employer can be asking individuals to determine whether they're qualified that kind of don't run afoul of the employment discrimination laws in the U.S. are you currently legally authorized to work for any U.S. employer? And will you now or in the future require work, visa, or status sponsorship? So again, as you all know, there are employment discrimination laws in the U.S., and you can't discriminate on the basis of national origin. Employers, though, are never required to sponsor an employee through the immigration process. You can certainly choose to do so, and we'll talk here about some of the strategies and why it might make sense for you as an employer to do so, but you're not required to. So you can certainly ask these questions. Are you legally authorized to work in the U.S., and will you now or in the future require sponsorship? You may still decide to sponsor that person, but it's good to know that on the front end, because oftentimes immigration is one of those things that needs to fall in place before the person joins you. Some terminology, immigrant versus non-immigrant. An immigrant visa or an immigrant status is someone who is in or moving towards permanent residency. So they would have kind of a green card. That's an immigrant status. A non-immigrant status is a status that has an intent to return back to that individual's home country. Most of what we'll talk about today are the non-immigrant statuses. Those are individuals coming over to work or to study, and then they have an intent to return home. Someone can come in as a non-immigrant and then move towards permanent residence in many statuses, but they are distinct statuses with distinct rights and responsibilities. There's also a distinction between a visa and non-immigrant status. So a visa is what's in the passport that enables someone to enter the U.S. The status is the status they have within the United States. Sometimes visas are only issued, say, for 1 year, but the status is approved at the consulate or approved with USCIS, the United States Citizenship and Immigration Services Agency, say for a period of 3 years. An individual can stay in the U.S. as long as the date reflected on their I-94 record, which is the bottom picture here that is on your screen. So that governs their status, their ability to stay and work in the United States. If they travel abroad, though, and try to re-enter the U.S., they need a valid visa to re-enter. So those two things are related, but they are distinct. The visa is to get in. The I-94 status document is what they need to stay in the United States. We'll talk here today about many different non-immigrant employment statuses, but we'll focus particularly on H-1B, TNs, which pertain to Mexican and Canadian nationals, H-3s for trainees, F-1s, which are students studying at a university who gain employment authorization, some during their studies as well as post-graduation. We'll talk about the J-1 exchange program, O-1 for outstanding professors and researchers, and then the L-1s, which pertain to multinational companies and individuals, managers, or specialized knowledge professionals moving from a foreign entity to a U.S. entity. There are a lot of government agencies. I always like to begin conversations by mentioning all of these, just because sometimes I refer to them as shorthand. As you'll hear today, immigration kind of involves a little bit of an alphabet soup. So I'll be name dropping all of these letters. I just want to give you a little background, be forewarned. Again, I'll provide the slides so you can always fact check me if you think I'm citing to something that doesn't exist. But I'll try to explain and define everything. But USCIS is the agency within the U.S. that you would apply to for immigrant privileges. ICE is kind of the enforcement arm, enforcing immigration compliance. CBP, Customs and Border Protection, is what an individual would confront at the border. It deals with kind of customs as well as individuals coming in and presenting visas or status documents. So people would encounter that at the Canadian border, the Mexican border, but they would also encounter it in the airport, just like we would encounter kind of customs agents when we fly to another country. Department of State runs the U.S. consulates around the world. So if an individual needs to apply for a visa, they would apply at the U.S. Embassy or the U.S. Consulate in that country, and that would be interacting with the Department of State. And then the Department of Labor often has a hand in the employment authorized non-immigrant statuses, like an H-1B. They set the prevailing wage, which is kind of the minimum wage for an area. And so we're involved in many of these non-immigrant statuses, as well as lawful permanent residents through the PERM process. So I'll just briefly go over this, but basically I'd say if you're interested, talk to an attorney. We'd be happy to talk to you. Some of it is kind of setting your organizational goals. Can you make your policies amenable to immigration and kind of structure them, not only so that you can enable immigration, but it's also something that if you're willing to engage with and willing to pursue immigration and sponsorship, you can really advertise. You have great universities in North Dakota. You certainly have workers there. You're obviously adjacent to Canada. So there's a lot of things you could do to kind of tout this and use that as both a recruitment as well as a retention strategy. You also need to define the jobs that you're looking to fill, and you need to look at their requirements and their duties. We'll kind of go through the non-immigrant statuses today, and you'll kind of hear, whether this position requires a bachelor's degree or whether it doesn't. But you need to look at the specific position, because that position, as well as the employee's characteristics, the country they come from, their training, will determine which non-immigrant solution is viable and is optimal for that employee and for you as an employer. Some of these statuses, some of these applications can take quite a long time. Some can be processed, directly at a port of entry. So like a TN, you can often get pretty quickly for a Canadian national, because they can just simply present the documents to a CBP officer at the border. Others may take months, because you need to go through the Department of Labor, get something certified before going and filing, say, with Immigration Services Agency in the U.S. So you just want to think about that strategically and craft kind of a long-term plan, both for that individual employee, but maybe for other employees going forward. Obviously, the employees also have goals, particularly if you're interacting with someone who's gone through the U.S. education system. Our higher education system is the best in the world. So people come from all over the world here. Often when they come, they end up wanting to stay. And so you may have interns, you may have clerks, you may have kind of summer workers, you may have people working with you post-graduation. Those are great people, and they're great candidates for your long-term positions, because you kind of get to test drive them, right? They're working on an F1 program, for example. We'll talk about this in a little bit, but they're granted 12 months of post-graduation employment, and then they can get up to an additional 24 months, so 36 months in total, if they graduated with a STEM degree, a science, technology, engineering, or a mathematics degree. And so you kind of get to test drive them, they'll work for you, and you can see, is this someone we want to retain long-term? Is this someone we want to sponsor to keep them on beyond that period? Obviously, the employees are interested in that, so they're kind of auditioning during that period of time, but they're also going to be looking for employers post-graduation that are willing to sponsor. And so if you're willing to entertain that, you might be able to get those new grads. You might be able to get people even to intern while they're in school, and just be more attractive as an employer for those immigrant employee opportunities in the future. Obviously, the employees may have other concerns as well, familial or kind of long-term immigration goals, such as lawful permanent residence or a green card. Basically, one size doesn't fit all. You need to think about the specific employee, your specific needs. There may be several options available, and then you need to kind of strategize what's going to be optimal, what's going to be the fastest or the most efficient, what's going to provide the longest employment authorization, what's going to be a good pathway to permanent residence if that's something that you and the employee want. So those are all things that go into a decision on an immigration strategy. So now we'll move on to those non-immigrant visa options. And I'll try to be brief on these. Again, there's kind of a full alphabet soup, but I'll try to give you just enough so that kind of the basic contours of employment authorized non-immigrant statuses. So some recurring things that will come up as we talk through these. One is whether the position is a professional or a non-professional position. And that is, frankly, does the position require a bachelor's degree? Professional position is a position that requires at least a bachelor's degree. It's not, obviously the person has to possess that, but an individual with a bachelor's degree could work in a non-professional position. That happens all the time. For it to qualify, say for an H-1B status, the position itself has to require a bachelor's degree, and that would need to be consistent across that position. Another thing to consider is the nationality of the candidate. Some visa categories, some non-immigrant statuses are only available for specific nationalities. The TN visa, for example, was based out of NAFTA. It's now called USMCA, but it's really the same. And that's just a treaty between the US, Mexico, and Canada. So only nationals of those countries are eligible for that specific status. You also need to look at the candidate's education and their experience. Again, if it's a professional position, the employee has to meet that. If they don't have a bachelor's degree, then you need to go back to the drawing board and figure out a status that would work for them. Sometimes a vast amount of experience can stand in for a bachelor's degree. So that would be another thing to look at. You also need to look at the prior or the current immigration status of the candidate to determine the optimal strategy. And then again, kind of the targeted employment start date. If you have a long lead time, you might consider one option. Short lead time, you may go with something that is kind of a step in the right direction, and then work on a longer term strategy while the employee is here working for you. This chart gives you a tidy explanation of whether a specific status requires employer sponsorship. As you can see, most of them do. The F1 program does not. The individual, the student, has to work with their university. For the STEM OPT, that additional 24 months of post-graduation employment for students that graduate with a science, technology, engineering, or math degree, the employer has to kind of fill out a training plan for them, but it's not sponsorship. For the H-1B and the E-3 occupations, the employer has to sponsor the L-1, H-2, temporary agricultural and non-agricultural workers, so kind of seasonal workers. They need to be employer sponsored. O1, employer sponsored. H3 trainees or J1 trainees, they need to be sponsored, the J1 by a program, the H3 by an employer. TNs need to be sponsored. The employer has to kind of have an offer letter and a support letter demonstrating that there's employment for that individual. And an E1 or an E2 is employer specific and needs to have employer sponsorship or involvement through that process. So these are probably the most common. Most of you have probably heard of this. It's kind of the vanilla ice cream of employment authorized non-immigrant statuses. This presentation today is timely because the H-1B lottery is held every end of March, beginning of April. They always announce them by April 1st. This year they ran the lottery a few days early, and so we got the final results for this year's lottery on Monday of this week. The lottery is for kind of all H-1Bs, and there are 85,000 slots. 65,000 are for kind of anyone with bachelor's or higher, and then there are 20,000 slots reserved for individuals with a master's degree from the United States or a higher level degree from the United States. So they run that lottery. This year, there seem to be even more than normal. Normally, there's about 300 to 400,000 applicants for those 85,000 slots. So it really is a lottery. And then if you're selected in the lottery, then you have to apply within 90 days for that. The nice thing is these are granted for 3-year periods, and they can be extended for another 3 years. They can also be extended beyond that if the individual has pursued permanent residence, likely with you as the employer. Obviously, the individual has to have at least a bachelor's degree in order to be able to apply for this. And again, it needs to be a specialty occupation or a professional position that requires at least a bachelor's degree. The nice thing about this H-1B visa is that it really applies to many different occupations in many different fields. So it could be managers, it could be analysts, it could be IT, it could be finance, it could be engineering, it could be computer and systems managers. It could be supply chain analysts. It could be logisticians or logistics analysts. It is widely applicable, again, as long as it requires a bachelor's degree and the person has a related bachelor's degree. So it's a great option. I mentioned that the lottery is held every March and April of each year. And that is true for kind of all employers. Think kind of private employers and nonprofits, generally nonprofits. Nonprofits that are affiliated with universities and universities themselves can sponsor H-1B candidates without having to resort to the lottery. So they can just sponsor them at any time of the year, and they don't need to wait to get selected in a lottery. So if you work for a nonprofit and have like an affiliation agreement or a memorandum of understanding, say with a local university, we run into this all the time with healthcare institutions that have like a nurse training plan or a physician residency training plan where physicians or nurses come through for some of their clinical training. Then that entity would be able to sponsor an H-1B candidate and wouldn't have to go through that lottery. So it's nice because there's not that uncertainty and there's predictability. You can apply any time of the year, you can sponsor, and you know that your case will be considered.
Matthew, do you know the reason behind the, what did you say, 85,000 slots? You know, would that number ever change, or how do they determine that?
That's a very good question. I have no idea how they determine it. It's certainly not benchmarked, so it's not, like it's not inflationary, because it's been that way as long as I've been practicing. So Congress sets that limit. The H2 program, for example, also has a limit. They've increased that. It would be great if they increased that. There's some talk right now on all the immigration attorney listservs that maybe this year they'll consider it, because it seems like there are over 500,000 applications based on the selection numbers. We know how many we submitted and how many got selected, and it's much lower than last year. So kind of extrapolating, seems like there were a lot more. So if you got 500,000 applications and there's only 85,000 slots, and there's there's a significantly low unemployment rate in the U.S., seems like it might be time to revisit that. These are people primarily who have been trained here in the United States, are finishing degrees here. They're trained professionals. They want to stay here. It's a big brain drain to have all these apply. I've worked with people with PhDs, and they've applied 4 times and didn't get selected, and they had to go back home. It's just a shame. They've been here for some of them half their life in school, bachelor's, master's, PhD, and they just don't get selected in the lottery. So unclear. I think maybe it was based on data at the time that it was set. It could also just be arbitrary. A lot of things are arbitrary. It's just, we're just going to pick a number because this sounds like the amount of immigration we want at this time. It's certainly not based on current need. So as I mentioned, the different agencies, there's the Department of Labor, which all of you are familiar with, and then there's the USCIS, the United States Citizenship and Immigration Services Agency. In the H-1B process, both of them are involved. So there's an initial application that you file with the Department of Labor, and that takes a week for the Department of Labor to certify the prevailing wage for that job with those requirements in your metropolitan statistical area, so kind of your specific region. You file that, it takes 7 days to come back, after which you can then file the I-129 form. That's the form that you file for an H-1B petition. This is true whether you're filing for an initial candidate, so you have a student working for you, or a student at the university that you want to sponsor to then work for you in H-1B status. It's also true if there's an H-1B candidate, an H-1B employee working at another employer who wants to move over to your organization. That's certainly possible. The benefit there is if they're already selected in the H-1B lottery, they can change employers. So they could come over to your employment, your workplace, and you would go through the same process, but you don't have to go back to the lottery. Once they've been selected in the lottery, they don't have to be selected again. They can change employers as needed. Again, they need an employer to sponsor them. They can't just go wherever they want, but as long as you as an employer were willing to sponsor them, you could sponsor them, and the employee can begin employment as soon as the application is received by Immigration Services. It doesn't even have to be approved. They've already been selected in the lottery. They have a valid H-1B with one employer. They file it, and they can change employers based on that filing. Normally, they want to stay until it's approved just because it's conservative. There's really no harm to you as an employer if they start on the receipt notice. But if it were, for some reason, ultimately denied, then that individual wouldn't have status and they'd have to scramble. They'd have 60 days likely to try to find other employment, or they'd have to leave the US. So normally employees, unless there's kind of some urgent situation, they'll kind of wait to get that approval notice. If you file it with premium processing, you can get a decision within 15 calendar days. Otherwise, the standard processing right now is about 2 to 4 months, depending on which service center you have to apply to. Here, again, you're going to want to work closely with an attorney. We'll assess the prevailing wage so you know what it's going to come back as from the Department of Labor. We'd want to go through and really provide detailed job duties. So it's gonna be more beefed up than your kind of standard job postings that you put out there, because it really needs to include the specifics of what the person's doing to show why a bachelor's degree is required and that a bachelor's degree normally would be required. The minimum degree requirement really needs to be specific. You can't just say a bachelor's in engineering, right? Because presumably you wouldn't accept a civil engineer if what you're doing is electrical. You're an energy company, and really you need an electrical engineer, right? So we work with you to define those, and then obviously you have to pay the required wage, which is either the higher of the prevailing wage, which is issued by the Department of Labor, or your actual wage rate. So, even if the prevailing wage is lower, if you pay all your employees, who are engineer ones, this level, you got to pay the foreign national the same. The idea is that, the non-immigrant process, this H-1B process, is not meant to undercut the U.S. workforce. It's really meant to augment it. So you have a need, you need to hire these individuals. And so having that prevailing wage certified means that these individuals are being paid whatever the prevailing wage for that area is, but your actual wage rate may be higher. We talked about this H-1B cap, so I'm not going to go into detail here. But again, if you're a private employer or you're a nonprofit and you don't have an affiliation with the university, you have to go through this lottery. And there is some uncertainty there. It's still worth it. If you're interested, we have employers who do this kind of every year. The nice thing is you don't have to prepare the full application. You just do an online registration, and we'd walk you through that process. If it's selected, then you incur the filing fees and the legal fees to fully prepare it. But it's pretty cheap just to have us kind of vet the case to make sure it qualifies, strategize, and then submit the registration. So you could do that. Hopefully you get selected the first year, but it's not the end of the world if you can do it again for that employee. In addition to H-1B visas, there are E-3 visas, and these function very similarly, but they are reserved for Australians. So this is one of those kind of nationality-specific ones. Again, it's a specialty occupation like the H-1B. It's a professional position, which means it requires a bachelor's degree. Here, instead of the 3 years, the visas are issued indefinitely in 2-year increments. You don't have to file a labor condition applications. So you're not filing with the Department of Labor, but you still have to pay kind of your normal wage. And here, the foreign nationals could apply. If they're in the U.S., they could file within the U.S. to USCIS. Otherwise, if they're in Australia, they can just apply directly at the U.S. consulate in Australia, get their visa, and then come to work for you in the U.S. So here, it's a non-immigrant visa. The H-1B is what's called a dual intent. So it's non-immigrant and immigrant, which is nice because if someone wants to move forward with permanent residence, they can still travel outside the U.S. and re-enter after they filed for their green card application. If someone is in a strictly non-immigrant visa, like an E-3, they could still potentially pursue permanent residence, but once they file that for a specific period afterwards until they get another travel document, they wouldn't be able to travel. So oftentimes you might start in an E-3 and then maybe have the person enter the lottery to try to get them an H-1B just so they have that flexibility to visit family or visit friends or even travel for your business while they're going through that permanent residence process. And here the E spouse is eligible for a work permit. Under the H-1B program, an H-4 spouse is eligible for employment authorization only if the individual has what's called an approved I-140 form, and that's kind of the employer part of the permanent residence process. That takes about 2 years to get, so that the spouse is not going to be able to work right away. It would be kind of a longer term strategy. Here, an E-3 spouse would be eligible to work and eligible to apply for a work permit and eligible for employment authorization. A nationality specific one, which is That's called an H-1B1. It is only for Singaporeans and Chileans. I've only come across a few of these in my years of practice because it's limited to 1,400 for Chileans and 5,400 for Singaporeans. It usually never fills. So it's available all year, but there's just not many numbers. And so it's not a very popular option for individuals. Again, specialty occupation, bachelor's degree required. For this one, you do have to file a labor condition application with the Department of Labor. The employee is really employer specific. They can only work for that employer. And here, like the E3, they can apply with the U.S. consulate or directly with USCIS. In this case, the spouse is not eligible to work in the United States. But some others, if that was something that the spouse wanted to do. Another one that comes up, and actually comes up quite a bit for my clients in North Dakota, are intra-company transfers. And so this applies where you have your employer that has offices around the world and or related entities around the world. And so if you wanted to transfer an employee who has been working with a related foreign entity, so maybe a Canadian operations, if the employee has been working there for at least 1 year in the last 3 years, then the employee would be eligible. The employee would have to have been employed as a manager or an executive or a supervisor or kind of a specialized knowledge professional with that foreign related entity, and would need to be coming to the US to do one of those things: executive, supervisor, manager, or a specialized knowledge employee. This is really attractive. It's a great way to get somebody here. You know, say you have a manufacturing line in Canada, and then you want to bring the person over to help advise your employees here, or to help set up a manufacturing line. Or, you know, you have kind of a VP or kind of a manager of operations in Canada, and you have a vacancy. You know, someone retires or someone leaves unexpectedly, and you need to fill that for a 6-month period or a year. You could quickly get somebody over. It's a pretty quick process. You don't have to file anything with the Department of Labor. So it's a shorter process than the H-1B process. And so it's really handy for transferring employees. It's limited to a 5-year total period for specialized knowledge professionals, or 7 years for what are called L1A executives or L1A managers. But it is kind of approved indefinitely if the employees are entering intermittently. So as you probably know, an individual cannot come to the U.S. From Canada if they don't have a visa and work. So they can travel over here for, just on their passport to see things, to go shopping, to go out to dinner, but they have to have a work authorized visa or status in order to work in the United States. That's the same for Europeans. They can come over on an ESTA for business meetings and business trainings, but they can't work in the United States unless they have a status like an L1 status. It's the same for people coming with B1, B2 kind of business or tourist visas. Those allow individuals to come for meetings and trainings, but not to work in the US. So the L1 is a great option if you have kind of a multinational company. Again, you're using the same form. There are some different requirements for it, but the individual, you'd apply here in the US, and then the person would process at their consulate. Some key things to work with your attorney on is to kind of determine the best classification. Some people, maybe they might be working in something like a principal engineer, which you might be able to frame as either a specialized knowledge professional or a manager. They might have, or a supervisor. They might have direct reports. So we'd want to work with you on that. There are some advantages to being a manager. One, you can extend up to 7 years instead of the 5 years for an L1B specialized knowledge professional. There's also kind of a fast track to permanent residence for L1A managers. So that's something that we would work with you on. If this is going to be something that you do more than once, then there's something called the blanket L, which is about the cost of one of these L1s. And the benefit there is then that you don't have to file with the Immigration Services Agency in the US. You don't have filing fees each time, and the employee can just make the application directly at their home consulate. So it's a lot faster and it's a lot cheaper if you're going to do this more than once. So that's something we'd work with you on and strategize on, but kind of put that in the back of your mind. If you have, if your organization has offices around the world, if you have related entities around the world, including in Canada, it could be a great option. Oh, one quickly go over this. This is limited to individuals with extraordinary ability. So it could be individuals who, have received a Grammy Award, who have received a Nobel, who have received a Pulitzer. It could be individuals who, have a really distinguished publication record and they've worked at universities. It's fairly limited. The individual has to be kind of really accomplished in their field, not just for their age. So a lot of times, we work with individuals who are finishing up their schooling, and the problem is it's not just this person's incredible or extraordinary for someone newly graduating. It's they're extraordinary in their field. They're at the top of their field. So it's a fairly high bar. We do these cases all the time, and would be happy to work with you. A lot of times it's with universities, but private employers can successfully sponsor an O1 visa. You just have to show that kind of their past proven track record or their publication record is going to apply to their work with your organization. Again, here we'd want to work with you to kind of really specialize and narrow their field of expertise. So it's not, all surgery, it's organ donation. It's not all organ donation, it's liver donation. It's not all liver donation, it's living liver donation. So you narrow the specialty because again, you have to show that they're at the top of their field. So you want to really kind of show their specialty. What makes them special and what is that field? They're the top of their field for this very specific area. You have to meet certain factors, and we go through that. We get letters of support from that individual's kind of referrers. So it could be universities, it could be past professors, it could be others in the industry. And then we look at the person's credentials to determine if that's a good fit, both for the O1 and also for the permanent residence process. So one that may be of particular interest to you all are H-2A, temporary agricultural visas, and H-2B, kind of temporary non-agricultural visas or seasonal visas. So an H-2A visa is appropriate for a foreign national who is coming to work temporarily or seasonally in an agricultural position. So here, some of the key things are the position must be temporary or seasonal. So it can't be kind of just an ongoing need. So it'd be difficult, say, for a dairy farm. It'd be more applicable, say, for a beet farm, where you have kind of a very specific beet harvest and beet processing timeline. You need to be able to show that. So we work with, forestry. We work with kind of employers who are doing kind of nurseries, right? Kind of that are working on landscape nurseries, right? That could fall under the agricultural. Everything happens during that very specific time frame of the growing season. So you could show that temporary need, and it must be agricultural, must be kind of on a farm setting. So livestock worker, farm worker, agricultural equipment operator, those would fall under the H-2A program. The H-2B program is non-agricultural visa, and it is defined as, again, temporary nature. The need is temporary. It's a limited period of time, such as a one-time occurrence or a seasonal need, peak load need, or an intermittent need. So the H-2B program is limited to 66,000 per year, which is divided into two halves. These numbers are sometimes increased, as they have been recently. As I was mentioning with the H-1B program, it'd be great if they increase those based on demand. But there is a limit. So it is kind of a lottery like the H-1B process. The employee must be on a list of specific countries or qualify for an exception. So you're limited to certain countries, like some of the other visas, and you're limited to a certain number. But it's certainly worth throwing your hat in, again, because once you get these employees, they can come, fill these temporary needs, and then you may be able to find another visa status for them to continue to work for you longer than that temporary seasonal need. We mentioned B1 business visitors in the past. And again, this would be, oftentimes this is used for someone to come to interview. If you identify a candidate from outside the US, say in Canada, they apply, they could come in the US, they could do on-site interviews, they could look at houses, they could kind of do kind of the setup pieces. It's limited, the business visit or the personal tourism visit has to be less than 6 months. They can't do work in the US. They can come for business meetings and trainings or contract negotiations, but they can't actually do work in the US. So again, it's a B1, B2 business visitor visa. individuals from Europe. It's called the ESTA program. Canadians don't have to apply for this. They can just come into the US and they're kind of presumed to be coming in for business meetings and trainings or for personal tourism reasons. So this is something that would be kind of a stepping stone. As an employer, this isn't going to help the employee work for you right now, but it could be kind of a way to do an on-site interview, do trainings or meetings with potential employees while they're waiting for a visa. We mentioned F1 students. Again, North Dakota has been graced with some great schools. And so this is what those international students would likely be on. It's called the F1 visa or the F1 program. So these are for full-time students who are enrolled in an academic educational program or language training program or a vocational program. They can work in some cases during their schooling on what's called curricular practical training up to 1 year. They can also work, again, as I mentioned, for up to 12 months after their graduation, and that's for all employees. And then for those employees who graduated in a science, technology, engineering, or mathematics field, they can extend it for an additional 24 months. So 36 months or 3 years in total post-graduation. So that's a great option. And again, it's a great option for you to see if this is going to be a good fit, if it's somebody that you want to sponsor for a different non-immigrant status beyond that 1 or 3 year period, and then also if it's someone you want to sponsor for permanent residence. J1s is pretty brief. They come over on exchange programs. It could be like an au pair. It could also be coming to the US kind of as a scholar or an exchange program. Could also be kind of camp counselors or individuals kind of working at resorts. So we work with a lot of resorts and kind of places up north that are very seasonal. So individuals could come over as part of a kind of an exchange program, and they could kind of work at those resorts or summer camps. So that's a good option if your industry falls within that. H3 trainings, again, this would be if you had multinational operations and you wanted to bring in people to learn a specific manufacturing line or a specific product line so that they could help set that up at your foreign operations. I won't go into great detail here, but just know that this is a trainee visa, which could be approved for up to 2 years for people to come in, could be numerous times during that period of time to complete trainings here in the United States. It is not an employment visa, so an H3 would not enable them to work in the United States. They can't be doing work that is normally performed by US employees. Again, the idea is to kind of protect the US labor force. They're coming here really just to train, so they need to have trainers here in the US. They need to have a defined training program. But once that's established, they can have their H3 visa, come in numerous times for that training, again, so that you can have kind of that knowledge transfer and build up your foreign operations. We mentioned TNs as being an attractive operations or attractive visa option for a border state like North Dakota, just like here in Minnesota. So the TN status permits a qualified Canadian or Mexican citizen to come to the US temporarily to work at a professional level. So it's limited to Mexicans and Canadians. So kind of permanent residents can't go. They need to be a Canadian or a Mexican. They also need to be working in an occupation listed on the occupational list for TNs. So that includes like accountants, engineers, attorneys, scientists, medical allied professionals, some nurses, RNs, OT, PT, RT, med lab scientists, college or university or seminary teachers. There's a whole list. If you have a Mexican or Canadian, this is kind of the first place you go, think, can this fit within this? Management consultants are one, which is kind of a catch-all category. They're difficult cases, but that may apply to your business if you're going to bring in someone kind of for a temporary period to serve a business need, particularly a managerial need. They're approved in 3-year increments. You can extend them indefinitely, but again, they need to fit within the occupational categories listed under the NAFTA regulations, and the individual needs to meet the minimum requirements. Normally, that's a bachelor's degree, but sometimes experience can stand in for a bachelor's degree. For a Canadian citizen, we would prepare the petition and they could just apply at the border, or they could apply at the Toronto Pearson Airport. They'd apply directly with Customs and Border Protection. Otherwise, Mexican citizens have to apply at a US consulate. Once that visa is approved, then they can come to the U.S. E2 treaty investors, those are available just for individuals of specific countries who are coming to the U.S. to invest in a business, up a business, but you could also be kind of an existing operation. Normal requires investment of at least $100,000, so it's going to be pretty limited. It could be viable if you had someone who wanted to partner with your business or invest in your business. That could be as the basis for them to come to the U.S. as an E2 treaty investor. There's a specific list of countries they have treaties with that qualify for E2 treaty investor. Other options, I've listed them here. Again, these are going to be pretty limited. Religious workers, cultural exchange visitors. We do these quite a bit for kind of language immersion schools or preschools. So individuals hiring individuals from kind of Latin American countries to come to the U.S. to work at say a Spanish daycare or a Chinese language daycare, an immersion program. That's a great option for them. P visa would be for artists or athletes or entertainers. Many dependents of many of these statuses are able to work or can apply for work authorization. Spouses of L1 individuals, the L1A managers, supervisors, or executives, or the L1B professionals, their spouses can work in the U.S. E2 spouses can work in the U.S. and H4 and J2 spouses can apply for employment authorization in some specific statuses. Green card, I'm going to quickly go through this. Again, I know this is a lot of information. You'll have the slides so you can refer to them, but there are a couple different ways to apply for permanent residence. First preference, extraordinary ability, outstanding researcher, or that multinational executive or manager. That really is what we talked about with the L1As. You need to have a foreign entity, a U.S. entity. The person needs to have been a manager in both of them, but that's a great streamlined process. You don't have to file anything with the Department of Labor, and it can normally be approved quite quickly. Second and third preference, both of those involve what's called the PERM process, and it's a pretty lengthy process. It takes about 2 years normally to go through the process with the Department of Labor. Second preference is available for individuals who are working in a job requiring a master's degree or a bachelor's plus 5 years of experience. Otherwise, they have to exhibit exceptional ability or they're doing work in the national interest. The third preference is for skilled workers, a job requiring at least 2 years of experience or a professional job. Just a bachelor's degree position. The main thing is you go through that process, the conclusion of that is an approved I-140. That's kind of the employer part of the process. And then the second part of the process, the individual applies for permanent residence by filing what's called the I-485. That right now is taking about 1 to 2 years to be approved. So it is a lengthy process. But at the conclusion of that, the individual has a green card. They have lawful permanent residence, which provides them stability and you as an employer stability and the security knowing you're not going to have to do extensions anymore. The employee is authorized to be here in the U.S., is authorized to work in the U.S., and that's really indefinite. You don't have to do extensions on their behalf. Most individuals can apply for that right away once that I-140 is approved. Individuals from China and India, because there are so many people applying from those countries, probably because they have over 1 billion people each, they are backlogged. So you can see here, this is a visa bulletin chart that the Department of State put out a couple months ago. And you can see individuals from India and from China are quite backlogged. So in the second preference category, for example, from India, individuals had to have gone through that about 2-year PERM process in October of 2011. So for them, they went through that 2-year process back in 2009 to 11, finished it in 2011, and they have just been waiting for 12 years. And just now they would be able to file for green card, which then takes about 1 to 2 years to be approved. So they have quite a lengthy delay. For most other nationalities, you can see it's kind of the all others category, this first column. They're either current or quite current. First and third are current in this month. The second preference was backlogged just a couple months to November of 2022. So that's kind of what you'd be looking at. It's just important to strategize and consider that. it still makes sense to move forward for Indian and Chinese employees that you want to retain, because that enables them to keep extending, say their H-1B, they can extend that indefinitely as long as they have that approved I-140. They can keep extending it until they finally are able to file for their green card. These are just some things to think about in crafting a permanent residence strategy, when to start the process, choosing the optimal process, and we talk through that with you, and then offering that pathway to permanent residence. They may have another pathway, such as family-based. If they marry a U.S. citizen, that could be a viable option for them as well. They might also qualify for investment-based immigration, say on the EB-5 program. I'm not going to go through all of these, but you'll have the slides so you can kind of strategize yourself. But I talked briefly about those at the very here at the very end. I just want to open up keys. Any questions from the group? I know this has been a lot, but hopefully this gives you some food for thought, and you hopefully some bells went off and your antenna went up a couple of times during today's presentation. So you see, oh, we offer this. There may be a couple different options for a workforce that we're looking to recruit, or we have this student. I wonder if we might be eligible for the H-1B. Hopefully some bells went off, and this could be the beginning of a conversation about how you could use immigration both to recruit as well as to retain. I'll just close by saying we also do a lot of compliance so I-9 audits, both kind of a regular internal audit for yourself to make sure that you're doing due diligence, but also if ICE ever shows up, we work with employers all the time on kind of going through that I-9 audit process, responding to the government, negotiating with the government, and coming to a resolution that's best for you as a company. So those are just some things to think about. Probably gave you a lot of food for thought as well as food for your stomach there. It looks like everyone's done. I talked so long, you're all done with your lunch, but I'm happy to answer any questions for you today.
So Matthew, I've got a question. I'm with Job Service in North Dakota, and our region has about 400 H-2B workers who come in. So what could be some of the best ways we could utilize the partners of or spouses of some of those individuals, because those are starting to come through?
Yeah, I would say give us a call. With this, I'd say we're kind of the premier H-2 provider for this whole region. We'd be happy to work with you. We have partners in Mexico and kind of agents we work with down there if you're looking to identify people. Otherwise, kind of working with those H-2 employees and their family members, would be happy to work with you on that. And then if you identify some people, maybe you have kind of a team lead who you're really impressed by, and you might want to move forward with sponsoring that person for another status to keep them here, or you want to specifically bring back certain people next year, we'd be happy to kind of talk through that with you. You know, they may be eligible for something else. If they're from Mexico, for example, they may qualify for a TN. There may be a way to kind of fit it within the TN regulations, and that would be a longer term status, not limited to that seasonal or that temporary need.
So I think that could be good for some of the farmers, and that would be really great for them to hear. But I'm just thinking, as a community, oftentimes the farmers are bringing the spouses as well, or the spouses are coming on their own. And so that's kind of an untapped force that we could utilize within the community. If we just kind of had a better understanding of getting those visas for them to work.
Kind of what you could sponsor them for. Yeah. No, exactly. We'd be happy to talk. And again, I mean, the more connected family is, you know, the higher the likelihood is that they'll want to come back. And so you always want to be able to engage those family members.
Are those spouses, I don't want to say limited, but do they also have to have bachelor's degree? I mean, are they exempt from certain jobs, or?
I think kind of from what I'm hearing your presentation, mostly like the H-2Bs would be the best bet, unless they were from Canada and Mexico. And that's a small portion of the people who are coming. A lot of Europeans, some in South America now are starting to come.
Yeah.
South is big.
Are they coming on the H2Bs or the
H2As.
H2As? Oh, okay.
We've got about 400
Oh, on the
last year
H2As.
on H2As. I haven't counted yet.
And those would be agricultural workers.
Those are the agriculture.
That's right. H2A's ag workers. Mhm.
So their spouses could be eligible for any position
The-
or?
Well, yeah, I mean, their spouses could be eligible for H2A. I mean, the spouses probably should be applying for the same thing, right? So they could just come over as a package deal. Both of them could work.
But the ones who are coming, most of them aren't working that are coming.
Right, so if
Got
there's got an RN, we would love to have that RN.
Right.
Exactly. Exactly. Yeah, I mean, if the spouse is coming over and the spouse doesn't want to do ag work, then you're going to have to find kind of some other status. A TN again is going to be really good for a lot of your kind of allied health staff, because a lot of those are specifically listed in the TN regulations.
So could they do training while they're here?
They could, we'd want to check specifically to see, and there may be kind of a trainee visa that you might look for, or they might be able to participate in kind of a J1 program, or even formally enroll in kind of an F1 program. But we'd be happy to kind of look at that with you.
Thank you.
Of course. Any other questions? I shocked you into silence.
Well, thank you, Matthew. Yeah, if you want to send me your presentation, I'll get it out to everybody who's here and even to our workforce committee too, if they want to see it. If you're comfortable, I'll share your contact information. Well, it's in your slide, I guess, so they can all have your contact information.